Judge ruling Wednesday that the voter-approved new congressional maps cannot be certified. The judge in Tazewell County says that Democrats did not follow the Constitution or the law in several instances during the redistricting process. And for now, the new congressional maps, heavily favoring Democrats 10-1, will not be used in November's midterm elections. Attorney General Jay Jones releasing a statement vowing to fight the decision, writing in part that my office will immediately file an appeal in the Court of Appeals. As I said last night, Virginia voters have spoken, and an activist judge should not have veto power over the people's vote. We look forward to defending the outcome of last night's election in court.
Hello and welcome, guys. Adam is here. This is happening right now. In a Virginia courtroom, a single judge sitting alone took a petition from Republicans who lost a referendum, ran through a grab bag of legal theories he didn't even bother to analyze in his own order, and declared every vote cast in that referendum null and void. Void ab initio, dead from the moment it was born. The citizens of Virginia went to the polls, made their voices heard, had their votes certified. And then one judge with one signature erased all of it. He didn't just rule against one side. He reached into the machinery of democracy and pulled out the battery.
Republicans in Virginia celebrating a circuit court win after ruling the newly passed Democrat-led redistricting map was unconstitutional just one day after it passed. Joining me now to react is Pittsburgh-based columnist and Washington Examiner political reporter Selena Zito. Selena, great to see you. Thank you for joining us. So clearly a whole lot going on across the country. But first, this news out of Virginia, where a circuit court judge is blocking this major Democrat win that took place just a day earlier for their redistricting effort. And Virginia Attorney General Jay Jones says that he's immediately going to file an appeal. So where do you see this one going?
In chaos. That's where I see this one going. Right. You know, this whole effort actually began in Pennsylvania in 2018 when the state Supreme Court overturned an existing congressional map in the middle of a congressional session.
Let's back up and walk through the sequence of events that led to this extraordinary moment, because the context is essential for understanding just how aggressive this judicial intervention truly was. Virginia voters had gone through the proper constitutional processes to approve a referendum, one that would provide for up to 4 additional Democratic seats in the state's legislative apportionment.
And tonight, Virginia voters approved a constitutional amendment to redraw the state's congressional districts. Just hours ago, the Associated Press called the results of the special election just before 9 p.m. As it stands right now, more than 95% of votes have been counted, with the yes votes standing at more than 1.5 million. The no votes stand at more than 1.4 million. The passage of this referendum will temporarily reshape Virginia's 11 congressional districts in a way that many analysts say would favor Democrats. 13 News Now spoke with voters earlier today at a Norfolk polling location who noted this push was a result of redistricting changes in other states. President Trump asked Republican-led states to redistrict, and Democrat-led states pushed back.
This wasn't some radical fringe proposal that materialized out of thin air. It went through the channels. It followed the procedures. It appeared on the ballot, and it passed. Not by a landslide, the margin wasn't enormous, but in a democracy, winning by a little counts just as much as winning by a lot. The voters spoke, and the answer was yes. That should have been the end of the story, or at least the beginning of implementation. But the political geography of Virginia contains multitudes, and what plays well in the northern population centers often lands very differently in the rural, deeply conservative southern counties.
If it had gone on normal, we wouldn't have had to do this. You know, that's a funny thing. If Texas and all these other states hadn't did what they did, this wouldn't be necessary.
Ahead of today's special election vote and the results, Representative Jen Kicken said she believes Virginia's current independently drawn districts give Virginians fair representation in Congress. She called the redistricting effort gerrymandering and unconstitutional. Meanwhile, several Democratic lawmakers tonight applauded the results of the special election. In a statement, Representative Bobby Scott said in part, there is no way anyone should have expected Democrats to sit idly by as Trump and MAGA Republicans participate in an unprecedented power grab.
Virginia, much like Georgia, is a state where your zip code largely determines your political reality. Once you get south of Richmond into places like Tazewell County, the landscape changes, the accents deepen, and the politics shift hard to the right. It was in this environment, in this specific county in the southernmost reaches of the Commonwealth, that Republicans went judge shopping. They found their receptive audience in the courtroom of Judge Jack Hurley. Now, let's examine what the Republicans actually brought to Judge Hurley's courtroom, because the complaint they filed reads less like a coherent legal argument and more like a scattershot inventory of every objection they could think of. They threw everything at the wall to see what might stick. They argued the referendum process violated various provisions of Virginia law. They pointed to a specific House Joint Resolution and claimed the referendum ran afoul of it. They invoked the Virginia Constitution, multiple clauses of it, arguing that the process failed to satisfy requirements about general elections, about submission clauses, about timing provisions, about the form of law requirement, about how certain offices get established. Each claim was a separate arrow in the quiver, and the remarkable thing about Judge Hurley's order is that he didn't bother to differentiate between them. He didn't weigh one against another. He didn't analyze which arguments had merit and which were stretches. He simply took the entire collection, gathered it up in his arms, and said yes to all of it. His order is strikingly, almost shockingly brief. It calls itself a final judgment, but it contains virtually none of the hallmarks you would expect from a serious judicial analysis. There are no pages of reasoning. There are no citations to precedent being carefully parsed. There is no engagement with counter-arguments. There is no weighing of equities explained in detail. Instead, the order simply marches through a list of conclusions, declaring the referendum void ab initio on multiple separate grounds, finding that it violates the House Joint Resolution, finding that it violates the Constitution because a general election was required first, finding it violates the submission clause, finding it violates the timing clause, finding it violates the form of law clause, finding it violates requirements about how offices are structured, and then, after cataloging all these supposed defects, delivering the knockout punch. Any and all votes cast for or against the proposed constitutional amendment in the special election are declared ineffective. Think about that word, ineffective. Your vote, the one you took time out of your day to cast, the one you believed mattered, has been rendered ineffective by the stroke of a single judge's pen. The order doesn't stop there. It continues piling on in ways that reveal just how completely Judge Hurley intended to foreclose any immediate path forward for the referendum's supporters. He finds that the Republican plaintiffs have standing to obtain the permanent injunctive relief they're requesting, a finding he announces without walking through the three-part standing test that courts normally apply with great care. He finds that the equities weigh in favor of granting that relief, again without explaining what specific equities he weighed or how he balanced them. He permanently enjoins the defendants and, crucially, their successors from taking any action whatsoever to further the referendum or implement its provisions. He overrules any outstanding pleas from the defendants. He suspends any bond requirement for parties who want to appeal, meaning the Democrats won't have to post a financial bond to challenge his ruling. And then, in a move that reveals perhaps more than anything else about the nature of this order, he denies the defendant's motion to stay pending appeal. In plain English, he refuses to pause his own ruling while higher courts review it. This means that right now, at this moment, the official state of play in Virginia is that a bare-bones, analysis-free order from a single circuit court judge in Tazewell County stands as the law of the land. The referendum is dead. The votes are void. And nothing happens until a higher court steps in to say otherwise. I want to pause on that denial of the stay pending appeal because it's a telling detail. When a judge issues a ruling that they know will be appealed, granting a stay pending that appeal is standard practice. It preserves the status quo while the appellate courts do their work. It acknowledges the humility of a single judge, recognizing that higher authorities might see things differently. By denying the stay, Judge Hurley signaled that he wanted his ruling to have immediate, disruptive effect. He wanted the referendum stopped in its tracks right now, even knowing that an appellate court might reverse him in a matter of weeks. That's not the posture of a neutral arbiter carefully weighing competing interests. That's the posture of someone trying to inflict maximum damage in the limited time before his hand gets slapped away. But here's where the story takes a turn that should provide at least some reassurance to anyone alarmed by these developments. Because this order, for all its sweeping language and final-sounding pronouncements, is almost certainly destined for the judicial scrap heap. This was always going to be a preliminary skirmish, not the decisive battle. The legal challenge to the referendum was always going to end up in front of higher courts. The Intermediate Appellate Court in Virginia will get its hands on this. The Virginia Supreme Court will likely have the final word, and here's the crucial thing to understand about how appellate review works in a situation like this. When a higher court reviews a lower court's legal conclusions, they don't have to defer to what the lower court decided. They don't have to give Judge Hurley's reasoning any special weight or presumption of correctness. The standard of review on questions of law is de novo, a Latin term that means from the beginning or anew. The appellate judges will look at the exact same legal questions with fresh eyes. They will examine the Virginia Constitution for themselves. They will read the relevant statutes independently. They will apply their own analysis to the House Joint Resolution and the timing clause and the submission clause and every other provision the Republicans threw into their complaint. If they disagree with Judge Hurley, they don't need to find that he was unreasonable or that he abused his discretion. They simply say, we read the law differently, and they reverse. Their judgment substitutes for his. Their analysis replaces his. His order becomes a historical curiosity, a document that briefly caused chaos before being vacated and forgotten. This is why, despite the alarming headlines, I want to be very clear about what this order actually represents in the broader legal landscape. It's a way station. It's a placeholder. It's a piece of paper that will serve as a vehicle to get the real legal questions in front of the judges who actually have the authority to resolve them definitively. If Judge Hurley had done the exact opposite, if he had run the table for the Democrats and dismissed every Republican claim with prejudice, the Republicans would have appealed and the exact same Intermediate Court and Supreme Court would be considering the exact same legal questions. The only difference would be which side was celebrating the temporary victory and which side was filing the notice of appeal. The substantive outcome, the one that will actually shape Virginia law for years to come, was never going to be determined in a Tazewell County courtroom. That said, we should think carefully about the broader political implications of what just happened, because even temporary judicial interventions carry messages. A Republican judge in a deep red county took a Republican petition aimed at undoing a Democratic electoral victory and granted literally every single thing the Republicans asked for, without providing any meaningful legal analysis to justify his conclusions. The optics of that are terrible. They feed a growing narrative that courts are becoming just another arena for partisan combat, that judges are politicians in robes who reach the result their party wants and then work backward to find some legal-sounding justification after the fact. The complete absence of analysis in Judge Hurley's order makes it unusually vulnerable to this critique. If he had written 100 pages carefully parsing Virginia constitutional law, engaging with precedent, and explaining why specific provisions compelled his result, critics could disagree with his reasoning while acknowledging he took the judicial craft seriously. Instead, he produced something that reads more like a party's proposed order than a judge's reasoned decision. The plaintiffs asked for these 15 things. Here are 15 yeses. Done. Final judgment. That's not how serious judging is supposed to work, and the appellate courts will notice. Let's zoom out even further and consider what this episode tells us about the state of direct democracy in America right now. This isn't happening in isolation. Across the country, we're seeing a pattern where voter-approved initiatives get challenged in court by the side that lost at the ballot box. It's happening in Texas, where Republican-backed measures move forward. It's happening in California, where Democratic-backed measures are being litigated. Florida is likely next on the list, with another round of Republican-favored initiatives heading toward potential legal challenges. In each case, the fundamental question is the same. When voters go through the proper procedures and pass something, should courts be able to step in and override their decision based on procedural or constitutional technicalities? The easy answer is that courts have a duty to strike down anything that genuinely violates constitutional requirements, regardless of its popularity. That's the core function of judicial review, and it's essential to a functioning constitutional democracy. The harder question is whether every procedural irregularity, every arguably missed step in the process, should be grounds for voiding an entire election result and disenfranchising everyone who voted. Somewhere between those two poles, judges have to exercise judgment. They have to distinguish between defects that go to the heart of the democratic process and technical imperfections that can be cured or forgiven without tossing out the voter's will entirely. Judge Hurley's order doesn't even attempt to make that distinction. It simply declares everything void and walks away. What happens next in practical terms? The state officials who were supposed to implement the referendum are now under a permanent injunction. They can't take any steps forward. Their successors, whenever they take office, will be bound by the same injunction. The machinery of implementation is frozen until a higher court thaws it. But that thaw will come, and it will likely come relatively quickly. The appellate process in Virginia will move forward. Briefs will be filed. Oral arguments will be scheduled. Judges who actually write opinions with reasoning and citations will take over the case. And at that point, the complete lack of analysis in Judge Hurley's order becomes a liability for the Republican position rather than a strength. It means the appellate court has nothing to defer to, no careful reasoning to evaluate, no detailed factual findings to review for clear error. There's just a series of legal conclusions that the appellate judges will examine from scratch. If the legal theories the Republicans advanced are genuinely strong, they'll survive de novo review just fine, and the referendum will remain blocked. But if those theories are as scattershot and grab bag as they appear in the complaint, the appellate court will dismantle them one by one, reverse the order, and let the referendum proceed. The final piece of the puzzle is what happens at the Virginia Supreme Court level. Depending on how the intermediate appellate court writes its decision, the Supreme Court might decide to take the case directly or might be satisfied with the intermediate court's work and deny further review. If the intermediate court writes a comprehensive opinion that thoroughly addresses all the constitutional questions, the Supreme Court could reasonably conclude that its own intervention isn't necessary. But given the stakes, given that this involves invalidating a voter-approved referendum based on multiple constitutional theories, the Virginia Supreme Court will almost certainly want to have the last word. And that's where the real judgment will be rendered, not by a single judge in Tazewell County issuing a conclusory order with no analysis, but by the highest court in the Commonwealth applying settled principles of Virginia constitutional law to determine whether the voter's decision stands or falls. Here's what I want you to take away from this entire situation, because it's easy to get lost in the procedural weeds and lose sight of what actually matters. A judge just declared that votes don't count. He did it without explaining his reasoning, without analyzing the law, without engaging with the other side's arguments, and without staying his own order to allow meaningful appellate review. That should bother you regardless of your political affiliation. It should bother you if you're a Republican who would be outraged if a Democratic judge in Northern Virginia did the same thing to a Republican-backed referendum. It should bother you if you're a Democrat watching your party's electoral victory get erased by judicial fiat. It should bother you if you're an independent who believes that courts should operate differently from legislatures, that judges should explain themselves, that the losing side in litigation deserves to know why they lost, and that voters deserve to know why their votes were thrown out. This order provides none of that. It's the judicial equivalent of, because I said so, and that's not good enough for a democracy. So, what can you do? Pay attention to what the appellate courts do next. The intermediate court's decision will tell us a great deal about whether this was just one rogue judge overreaching or whether there's a deeper problem in the Virginia judiciary. Watch for whether the appellate court takes the time to write a careful, thorough opinion that engages with the substance of the legal questions. Watch for whether the Virginia Supreme Court grants review or lets the intermediate decision stand. And most importantly, remember that this order, however alarming it looks on its face, is not the end of the story. It's barely even the beginning. It's a piece of paper from a single judge who granted everything one side asked for without explaining why. That kind of order rarely survives contact with actual appellate scrutiny. The higher courts will do their job. The law will be clarified. The referendum will either be validated or struck down based on real legal analysis, not on a conclusory final judgment that reads like it was drafted by the winning party's lawyers. In the meantime, let this serve as a reminder that democracy is fragile in ways we often forget. It depends on institutional norms that can be bent or broken by individual actors. It depends on judges who take their obligations seriously and explain their decisions rather than issuing decrees. It depends on appellate courts that correct lower court errors and maintain the integrity of the system. And ultimately, it depends on citizens who pay attention, who demand better, and who refuse to accept that a single judge's unexplained order can erase the collective will of millions of voters. The fight over this Virginia referendum is far from over. The real battle hasn't even started yet. The only thing that's happened so far is that a judge in Tazewell County gave Republicans a temporary victory lap. The referees haven't weighed in yet. The higher courts are coming, and when they arrive, this final judgment will likely turn out to be anything but final.